Okay, so Mr. Segura, when you were here and entered the plea of guilty, asked you some specific questions about pleading guilty freely and voluntarily, and then pleading guilty because you actually did what they charged you with, and your answers to both of those were yes. The version, however, that your version that I received here in the sentence report is a little different. It says that you didn't have the drink until your vehicle was stopped. And so your version, if I'm to believe it, is that you stopped at the Taco Bell.
Yes.
You drove to the Taco Bell.
I drove to the Taco
You stopped at the Taco Bell. And you drank while your vehicle was stopped.
No, ma'am. I was outside the week when.
So you hung out at Taco Bell
I was
and drank.
I was waiting for the line and we were talking, trying to get my food.
Yeah. Let's do that. Raise your right. You swear or affirm that the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
So help me God.
Okay. So you're saying that you got to Taco Bell. You drove to Taco Bell.
Yes, ma'am.
Okay.
I made the right turn. With my signal and everything. And I was about to park. I feel. That's where the swerve came in. Okay, obviously, it happened. And so.
I'm not worried about. Hold on.
Yes, ma'am.
Right. I want to know when you got to Taco Bell, regardless of whatever happened.
Right.
Did you go through the drive-thru or did you park?
No, ma'am.
Listen to my question. Did you go through the drive-thru or did you park?
I parked.
Okay. So when you parked your car at Taco Bell, you start having alcohol at that point?
No, ma'am. I got out of my vehicle to see how far, traffic was
Okay.
He had some car in front of me.
In front of you for what? You were parked.
Yeah, I was parked.
Were you parked in a parking spot or were you parked in the drive-thru?
I was not exactly in the drive-thru. I was in front of the store. At the end of the store.
Okay.
Right. I guess sitting there to drive-thru line.
Were you waiting for the drive-thru?
I was waiting for the drive-thru.
Okay, listen, here's the thing. You're not going to try to trick me up with semantics.
No,
hold on, don't talk over me.
Yes.
When I say, were you going through the drive-thru or were you parked? What does that mean? That means, did you park your car because you're going to go in the store, or were you waiting in the line to go through the drive-thru?
To go through the drive-thru.
Okay. I may look.
This is a classic courtroom moment. The defendant is trying to win on technicalities. Parking spot versus drive-thru. Engine running versus stopped. But judges aren't fooled by word games. In DWI law, actual physical control matters more than movement. If you're behind the wheel with access to drive, the law considers you operating. Semantics don't beat statutes.
I don't know, like I'm 12 years old and just fell off the turnip truck, but I'm not. So you're in the line and you get out of your vehicle, right? Because there's a long line, the cars aren't moving. Right. So you get out and you decide to start drinking here in the park.
No, ma'am, I didn't drink until I got back in the back of the car.
Okay. But while you were at the Taco Bell, you started drinking. Had you drank before that?
No, ma'am.
So you're telling me that you started drinking at Taco Bell?
Yeah, I was drinking. Thank you. That's how the deal. Yeah, it was on.
So from the time that you started drinking at Taco Bell to the time that the officers got there, about how long was that?
Maybe 20, 30 minutes, whatever.
Okay. How much did you drink between that?
I had a whole.
Mm-hmm.
Yeah, but it's strong.
Mm-hmm. Just one?
It was a 40 ounce.
Right. So you drank the whole 40
I was
ounces.
drinking out of the thing. After the fact that
You were drinking out of what?
I got back in the car and I started drinking.
Right. So how much of it did you drink?
Soon a lot of it.
Okay, so let's just say you drank most of 1 40 ounce.
Everyone can even take it.
So that's your story and you're sticking, hold on. So is that your story and you're sticking with that you drank most of 1 40 ounce beer in about 15 to 30 minutes and that you hadn't drank anything before then?
No, except for that night before. About 2 o'clock that morning. with your whole blood. Alcohol stays in your blood. What do what I drank?
So your test on this night, after drinking most of 40 ounce, was 0.188. And you're wanting me to believe that that's based on most of one drink, and that maybe you still had alcohol in your system from the day before.
Yes, ma'am, but what I remember because my memory now, I have no business trying to teach you this way. I'm telling you, the God's son is true. Like I said, I had alcohol in my system from the night before.
How much did you drink the night before?
Well, I was intoxicated.
So what you're telling me then, if you had that much alcohol in your system from the night before, that you were still probably hold on. Watch where your story's going.
Yes, ma'am.
So you're telling me you had so much in your system the night before that it was going to still be in your blood, and you had just driven to the Taco Bell.
No, I drove to the Taco Bell later on that evening.
You're not right.
And it wasn't a full 24 hours.
Right. So if you're saying that 0.188 is because of the night before, then all likelihood you were drunk when you were driving from the night before, if I'm to believe your story that you only had most of one drink while you were there. See how that doesn't make sense?
Here's where the judge dismantles the story using simple logic. A 0.188 blood alcohol level doesn't magically appear from most of 140 ounce in a short window, especially not when paired with claims of sobriety while driving. The judge is showing the audience what courts do best: apply real-world science to courtroom excuses. And the math just doesn't math.
Okay. All right. So let's go back. Obviously, there's some medium acceptance of responsibility, so we can go forward with the argument. Unagreed, Mr. Burbank. I'm sorry, Mr. Coleman, you have a witness. Mr. Robertson, if you please raise your right hand, sir. Do you swear or affirm the testimony you're going to give hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may proceed.
Of course, we will, Mr. Robinson.
Sure.
Mr. Robinson, you're certified. You had that opportunity to release his application to the state. We then include prior engagements for a Defendant Mark Anthony Seur. Showing you what the Mark states exhibit number 1. The state exhibit number 1 is here. That summary of 20 is felony judgments that you reviewed. Take your 20 is prior judgments. So it is number of yes, sir. The association to at least one of the DOIs again on each day compare judgments here again. And in addition to prayers that you there and confirm you have with also personal identifying institutions, SID numbers, and used to the honor this time, all states including number 1, which is summary, the actual judgments themselves, they are marked states ingredients.
Let me just ask: Are there any on that list that aren't already on the pre-sentence report? Why are we doing that?
It's been a while.
Mr. Burbank, does your client hold on? Does your client have any objection or any reason not to for me not to take judicial notice of the PSI for sure, that those prior offenses listed in there, the ones that are convictions, are any way wrong? Okay, so what about for the felonies? Are there one or more that are he contest?
It's catch 22.
Okay.
It's quite not too often, so that you got to.
Oh, okay. So
Yeah. So it's two felonies that I think are crucial.
all right. So then, do you have any objection to the states? Was it 1 and 2?
Stage 1 is a
I object to stage 1 to those.
Okay. My main concern are the felonies. And if you have the actual judgments on those, why don't we do that way, even though it might be a little more documentation, Mr. Coleman? If you will go through primarily the felonies, would be my concern. And
summary and just put the felonies in the background. Because what I want the court to do is I want to talk about summary.
well, I want to talk about, I mean, I've got the pre-sentence report. So I need to know if there's something in the summary that's not in this report. That's what I'm kind of used to looking at. I've already made my notes on it. I've got highlights. So if there's something that's not on that already, let me know. If there is, then obviously I will. So are that there are 19 misdemeanor convictions on the pre-sentence report, and that I've got 8 felony convictions.
I think you don't have 8 judges. I think that there's at least one of them that was refused. Your both PSI and first needs to be refused.
I have stopped. Don't let us figure it out. So what I show with convictions on the PSI, I've got a 91 possession of a controlled substance. There was probation that was revoked for 5 TDC. Got a 96 manufacturing delivery of a controlled substance, 1 year of jail. I've got a 03 possession of a controlled substance, 18-month state jail. Got an 03 from April manufacturer delivery with 6 months state jail. I've got a January of 15 obstruction or retaliation, 2 TDC. I've got at the same date a harassment of a public servant, 2 TDC. I've got a driving while intoxicated, 3rd or more. Offense date of 11 of 15, 3 TDC. And then I've got an 18 obstruction retaliation with 5 TDC. Totals 8 felony convictions.
That's more than what I had.
So are there then, I need at least whatever you have, because he has pled not true to the ones alleged in the indictment, which, pull it up.
There's state 5.
They have a room.
Yes. Give him a second.
The
So
document's right there, see?
Hey, Mr. Burbank, you asked a question. Let him answer the question.
Yeah.
Calm down.
Would.
He's on it. I'm sure. Mr. Robinson?
listen. So what I did is I took that even for I used to be print opens all that was book. And then I can put these documents to this document to the rest of these documents. Some of them have fingerprints, some of them do not have fingerprints. They however all have new date of birth and the virus information, which is what I do to make that.
So, in does state 5 have the thing? How did you, do state 5?
Several don't have fingerprints.
Okay.
There are.
Go ahead. Let me also, let's kind of stop, because there might be, right now, I told you to kind of focus in on the 3 that are in the indictment. The state did file a notice of intent to use prior convictions to enhance punishment back in January of this year of 2024. And so that motion lists it lists 6 felony offenses. So we obviously need to go through these 6 potentially as well. Here's what I want to do. I want to take a quick break. I'm going to take care of this other matter. Y'all go through, get it organized on 6 that are in that motion. If any that are in that motion are not duplicative, I want to know which ones are duplicative of the ones in the indictment so that we're not talking about them twice. If there's 3 in the indictment and those are included in the motion, some of them are, some of them aren't, be ready to tell me so I can know which ones we're going through so that I know if there's 6 that are being proved up, if there's 8 or 9 that are being 8. I show 8 on the PSI, potential felony priors. So I want to know kind of where we are on all that. Y'all can just go sit down and take a break. Don't leave the courtroom, Mr. Seur.
You're always listening.
Or because it was reduced, it wouldn't be a.
I do not see it.
Date of birth is correct. Name appears correct. So.
That is correct.
Let's see, Robinson. Is it fair to say Mark Anthony Seur? Say he name is not Mark Johnson.
I don't have any other marks. The one else.
Put your hand down. And Mr. Seur, sitting there thinking that me asking these questions is somehow on your side and making the head nods and all the things that are going on, you need to stop.
Notice the shift here. This isn't just about evidence anymore. It's about demeanor. Head nods, reactions, gestures, judges see it all. And when a defendant appears to believe the court is somehow on their side, that perception alone can tank any remaining goodwill. Courtrooms reward accountability, not performance.
It's not helping. So here's what we're going to, hold on. Here's what we're going to do. Mr. Seur, I want you to remain here in the courtroom. Mr. Coleman, I'm going to recess this hearing until 1 o'clock. When we get back at 1 o'clock, during lunch, I need it all ready to go, lined out, whatever. If you want me to take it into consideration, now I've already taken judicial notice of the PSI, but if there are objections, this is not him, then this is what I'm asking you to do, Mr. Burbank. Specifically go through the PSI, or actually specifically go through the second amended notice of intent. And I want you to go through that, and I want to know which of those, and if it's all of them, that's fine. But if you're saying that this is not him, it's someone else, then I want to know that. If you're saying it's not admissible because of some identifying factors, I want to know that.
Well, I believe that the ones that are arguing about the verdict, she wants.
So then we're arguing right now about a misdemeanor. If we're not going to argue about misdemeanors, are there any on the list of misdemeanors that you were arguing that are not Mr. Seur?
No.
All right. So then, do you have any objection to my taking judicial notice then of the PSI, which includes 19 prior misdemeanor offenses?
No.
Okay. Then we can stop with all the misdemeanors. I don't even need to see those judgments. Are there any other felony? I have 3 in front of me now. Any Stage 2, Stage 6, Stage 7. I have Stage 2, 6, and 7. These are all 3 third-degree felony offenses that have been admitted in evidence. I have not made findings yet, but they are admitted. With regard to other felonies that you want me to take into consideration for punishment purposes, not necessarily enhancement, I know you said there was state jail that you kind of stopped on. Are there any?
State jail. I think here the limit on.
Okay. So with regard to the state jail, Mr. Burbank, it looks like on the PSI, I'm looking back now at the PSI, it appears that 2 of the several felony offenses, only 2 of them appear to be state jail felonies.
And those back in 2003.
Correct. And 6 months. Is there an objection to those, or me taking those into consideration, or any that's not Mr. Seur?
Right.
All right.
I also want to 96. but I'm not sure. It said 1 year still, right? That's the mystery.
That would have been probably before state jail, so I think that's the one that might have been reduced that they were talking about. So that one I'm not taking into consideration as a felony. I am taking it into consideration as a lesser included or a reduction, whatever it was, to that jail time county. Perfect. No, let's keep going. So that means at this time, then, based on the evidence, do you have any evidence, Mr. Burbank, with regard to the findings that I'm going to make on count State's Exhibit 267?
One that was up to Judge.
Right. So, I mean, I know you had, I don't remember now which one, but
The ones I filed were the ones I had objection about, so this position.
Okay.
Identified. That's all objection.
then at this time, I am going to, based on the evidence that has been included in the PSI as well as State's Exhibit 2, 6, and 7, I'm going to find that the prior criminal offense felony in cause number 15-23847, which is number 15 in the state's enhancement, is true. I am also going to find State's Exhibit number 6, which is cause number 15-22572, which is number 14, State's Notice of Enhancement, make a finding that that is true. In addition, State 7, which is cause number 18-30235, which is number 16 in State's Notice of Enhancement, I am also going to make the finding that that is true. So that are those 3 prior felony offenses. I have made findings of true. I am taking into consideration all of the other ones with the exception of State's number 5, which has not been introduced, but that was we discussed, which is cause number 60328. I am going to make a finding of not true because I don't have enough evidence in that. It sounds like in that judgment to link Mr. Seur well enough to that offense. Everything else I'm taking notice of for punishment purposes.
Robert the bond of the other is that for 2096 in the PSI, in which he received 1 year before the state.
I just said that a minute ago. So in 96, I'm taking notice that that was reduced and is not a felony. So what that means is that it appears as though there are this would be the maybe the full. All right. So yes, I took judicial notice that that one was reduced from a felony to a misdemeanor on the conviction day.
This moment is subtle but huge. The judge is being precise, only enhancing what the law allows, rejecting what isn't sufficiently proven. That's not leniency. That's judicial discipline. But don't get it twisted. Even when some priors fall away, the remaining convictions are more than enough to trigger catastrophic sentencing exposure.
In 97, right? So, Mr. Burbank, you may proceed with argument.
My client.
Yes, and he's already been sworn in. Thank you, Ms. Roberts. Go ahead, Mr. Seur, or Mr. Burbank.
Further today, Mark determined what punishment tell the court why. Well, what are you asking for? Let's start with that one.
First of all, Jill,
Yeah.
forgiveness. To begin with, a lot of bad person. Twice out of once in time. So all I want to do, I'm still, I worked all my life. kids is out.
Where do you work?
I work. So, starting off, I worked for Little Women's when I was a kid. So 18. After that, I graduated and I was a teen worker. I've been working in the plant for over 20 years. All my life I've been
How many years?
Yeah. And all different types of jobs, all over.
How many years? Sure. How many years have you been?
First of all,
How many years have you been?
all together with everything, I've been doing over.
Right? How old?
I'm
58 years old. For 10 years. Okay. TWIs and other things. So, what mercury are you asking for from this court when you have 19 misdemeanors, 7 or 8, 6 or 7 felonies? Why should she consider something less? Give her a reason why.
It's weird.
What's changed?
I didn't do half the things. It's not.
Mark, plead guilty to him. Okay? That's over with. Right? The day for you in reference to court, the day for you to say, I didn't do this is over. You accepted the plea. Now let's come to the chase it. Because she could find the allegations of what she did true, the consideration is 25 to life. Right? And guess the most you've had up until this was fired, right? Okay. So now let's go first to when you were arrested, when you were working. Okay. What did you discuss?
I got real true all right. I got prostate. Like straight.
Are you on facility? Okay. When were you first on this facility?
Like 2020.
Okay, so 2020, you're on facility. So while you're on disability, why are you drinking the 40 ounces at a time? Or drinking the night before to where you're up?
So it's
Explain to me.
I just lost my brother. I was running my phone. Because alcohol just don't win. You got no good.
Okay, so you have a problem. One of the things you talked about was, when you came to me was that you never went to a program.
Yeah.
You never went to a drug program?
I got yeah. Never had a chance on horses.
Well, you got
What about when you weren't on probation? What about the times when you weren't in prison and you knew you had a problem and you wanted to stay out of prison?
Yeah, well, I said the right something else.
No, what? That's since you've been in. I'm talking about the rest of your life. I'm talking about the times that you got arrested 43 times for public intoxication, 39 traffic offenses, 17 times you didn't appear in court, 5 disorderly conducts, 4 open containers. I mean, these are the ones that aren't even listed on pages.
Yeah, 5 different other ones.
Okay, so you're gonna stick with that this isn't you.
No, I'm not making no excuse. I have very much high respect for
What's been okay? Do you really? You do. So that's the 19 misdemeanors, the assaults, the terroristic threats, the trespassings, the 1, 2, 3, 4. This is your 5th DWI, your 2nd felony DWI. By what you need to understand is that by not really taking personal responsibility and making us go through this circus that we've been going through now for an hour and a half of trying to prove that you actually have been convicted of felony offense when you know darn well that you have.
This is the emotional climax of the case. The judge isn't angry. She's exhausted. Exhausted by denial, by deflection, by decades of chances wasted. Courts can forgive mistakes, but they punish patterns. And when someone refuses to accept responsibility after 40-plus arrests, the system stops asking what and starts asking how long.
Makes no sense to me. Mr. Coleman? Argument?
Yeah, if you grab them, 25 years.
Go ahead.
One of the things referenced to the process is somehow I did not get your the what she could build by life over. He's got a problem. Spent most of his life in and out of alcohol. I told one thing I was judged with his alcohol. He wasn't youthful. Police and law taking into probation. Find true to the allegations. He said this the same thing. But screws up. He's looking at 25 proactive field to find this. Comes back. Here's the problem. Is you don't know what happens when it comes down to the law. Reference to it. But I've done it before, judged other courts with
You can't give deferred on a driving while intoxicated. Now, we've done that on other types of offenses, but I can't do it on this. That's not an option. Okay. All right, thank you. Mr. Seur, you're starting with the beginning of this hearing when we were going through the just the nature of the offense. Starting there, we went down the wrong path. It makes no sense. I don't believe it. It doesn't add up to what your blood alcohol level was. How you say what happened that night doesn't line up. It just doesn't. I get that 40 ounces is a big beer, but if you've been an alcoholic for as long as you're talking about, that's not going to get your blood alcohol to what it was that night, which was almost a point. Was 0.188. I have already found those 3 prior offenses true. Those are all felony offenses from different conviction dates. I'm going to find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated, third or more. I'm going to sentence you to a term of 25 years in the institutional division of the Texas Department of Corrections. In my opinion, you're lucky that Mr. Coleman asked for 25, because I'm not sure that you really deserve that with your criminal history and with how you...
25 years. Not because of one night, but because of a lifetime. This sentence isn't just punishment. It's the legal system saying, we tried everything else. The real question for viewers is this. At what point does mercy become negligence?